and dissolution of LLP. Friends, a lot of discussion happens on LLP. People are not still well versed or having hold on the compliances, uses, disadvantages, obstacles, issues as regards LLP operations. And that's why even the closure is a far more different topic, because not many LLPs are closed, because LLPs itself has a little complex subject in the view that people has not utilizing it, not yet more. It is catching up. It's not that it is not catching. We had that's why webinar series on LLP, which will talk on the different aspects of LLP. We covered merger and everything like Companies Act, and we try to give in-depth knowledge and try to cover and touch up all the questions and issues on LLP. Today is this last session for this series of LLP. We have tried to give maximum and share knowledge with our participants, and we have gained the knowledge from our participants as usual. As we say that this is a knowledge sharing session and we want everyone to participate as a participant. Am I audible? Somebody is putting that. Mr. Bala,
you are audible.
Yeah, I'm audible. No?
Yeah,
I think you are very much audible. I think the person has to check at his end. Otherwise, your voice is very clear.
Yeah. So, friends, okay, thanks. Thank you, Mr. Singh. So, today is a session, last session on this series of topic is winding up and dissolution of LLP. And we have with us Mr. Chetan Gupta, Managing Partner, APAC and Associates LLP, who is not only fellow company secretary, but insolvency professional, my professional colleague in insolvency professional as well. Right person for the topic. And that's why, welcome, Mr. Chetan. Thanks for your time.
Thank you, ma'am. My pleasure. Yeah.
And we have with us Mr. Bala, our own panelist, moderator. Unfortunately, Mr. Sudhakar is not able to join today. He has some other work. And hence, as you know, and Mr. Bala, a veteran, fellow company secretary with decades of experience. I need not introduce him, and you all know him very well. We have with us Ms. Harshita. Ms. Harshita Nahatkar is Assistant Manager from Pune office of us Pune branch. And thanks, Harshita, for she is going to present today this topic on Master Class LLP, on winding up and dissolution of LLP. I would like to formally introduce not other than our main panelist, Mr. Chetan Gupta. Mr. Chetan Gupta is a fellow company secretary since 2006, and he is also insolvency professional. He is a managing partner of APAC and Associates LLP company secretary, himself as LLP. So that's why it's more relevant he is there. And he is the premier provider. This firm is providing company secretarial service in India, offering an extensive range of service, including formation, running, closure, compliance under various Companies Act, FEMA, RBI, SEBI, IBC, other corporate law. With team of 15 professionals, serve the clients, expertise in establishing corporate governance, compliance management system, and representation with various authorities. And they provide services to MNC, SME, beyond, and various clients. Welcome, Mr. Chetan. Thanks a lot for your time. And I'll request Mr. Chetan to say a few words on the topic, then Mr. Bala, and then Ms. Harshita, you can start. Friends, as usual, we'll request you to post your question on the chat box, and which will be replied at the right time. Mr. Bala will take during the topic. And at the end of the session, we will allow you to speak. You will raise the hands. In between, still, if you feel that it is important, then you raise the hand. This is for administrative purpose. For seamless running of the presentation. Over to Chetan bhai.
Thank you so much, ma'am. It's my pleasure to be a part of Mehta Mehta, the web series, the webinar that you are organizing on the LLP. Just for today's topic, winding up and dissolution of the LLP. So there are a lot of confusion. I think, as Dipti ma'am has told already, the LLP is still to be explored by the professional fraternity. Under the LLP, how it can be winding up under the LLP Act. Also, there is a provision under the IBC. Also, there is a provision for voluntary liquidation. There are a lot of confusion among the members. Which process, in case they want to wind up and dissolve the LLP, what process they will follow as per the circumstances. So I think that is a good seminar that will cover each and every provisions that is given under the LLP Act, and definitely I will share my experience with respect to the closure of LLP also under the IBC that I have taken in the past. So I think with that, after the presentation, it will be better if when the participants will go through all the provisions. So then, based on the query, I can add on to the topic or to the query.
Okay.
Thank you so much.
Thanks. It's a rare experience, friends, that LLP closer and Mr. Chetan is having that. So we are fortunate to have him as our panelist. Thank you. Yeah, Mr. Bala, please.
Good morning to all of you. I have a great pleasure in welcoming you all for this particular session on my own behalf and also on behalf of my family. As LLP is the one which is the hybrid form of the company and the partnership together, which is actually catching up as Dipti mentioned to it. Today, we are actually looking at the winding up and the dissolution of the LLP. And as you are all aware, more or less, the winding up process ultimately resulting in the dissolution and finally ROC taking of the name of the company. What is applicable in the companies, more or less the same procedure which are actually applicable to LLP also, because LLP does not have any particular exception or exemption or consumption. One has to undergo all the procedure which are actually applicable under the Companies Act, whatever the provisions are there. Of course, there are different rules have been actually framed. There is a LLP winding up and the Dissolution Rules 2012, which is actually brought in. That talks about the LLP mode of winding up, etc. As you are aware, here also we have the winding up either voluntarily or by order of the tribunal. Then when you come to the voluntary winding up, there are different ways of winding up and the voluntary winding up. Winding up is a long process which actually takes and go through the various legal procedure, etc. and other thing and all through the NCLT. And ultimately, once the winding up process is actually completed, the LLP get dissolved and finally the name is taken off. And today's webinar, what we are going to talk about it, I think Harshita will actually take us through what are the rules which are pertaining to the winding up and as well as the dissolution. She will also touch upon the key definition when you are talking about the winding up. What happens is what happened to the partners who are actually there, who are running the show. When you appoint the liquidator, what happened? What is the exact situation? What are the complaints which are actually arising out of it? Who will actually comply? And what is the procedural aspects of the winding up? All these nitty-gritty she is actually going to run through. And incidentally, we have Mr. Chetan, who himself is a vast experience in the LLP. As I was talking to him yesterday, I understood that he actually handled the LLP winding up in conjunction with the IBC Act, as he mentioned in his opening paragraph. A lot of procedural aspects, a lot of form filing, etc. And even the additional disclosure when it comes to LLP, all those things are all nitty-gritties are involved actually. So we are actually very glad to have Mr. Chetan Gupta with us, who will actually share his experience on the appropriate times once we are running the slides. I'm very sure in the process, we will all learn a lot of things from each other. As you've seen for the last 2 years, this webinar is actually going on. It is a very good learning session for both of us, audience, and as well as the people who are presenting and panelists, etc. It is both the ways actually, because continuous learning is a never-ending process. I definitely look forward to learn something from this seminar today. And same thing, I hope you will also enjoy the things. As Dipti puts it very categorically, please write your queries on the chat box. We'll be taking from relevant times, and these will be getting answered. Whenever it is required, you can raise your hands and you will be permitted to talk. We can hear you also. I think with this, I will ask Harshita to run the presentation. Over to Harshita, please.
Yes, sir. So is it visible?
No, not yet.
Yes, now visible.
Now it is visible very much.
Okay, sir. I, CS Harshita Nahatkar, wish everyone here a very good morning. It is an honor that you all joined here for our masterclass on winding up and dissolution of LLP, Part 7. As we all know, the LLPs are new form of business entities which were introduced through LLP Act 2008 in India. It has the benefit of both a company and a partnership. The LLP is a body corporate and an artificial person which is created by a legal process called incorporation. And in same way, its existence comes to an end by another legal process called dissolution winding up. On the dissolution of LLP, its name is struck off from the records of ROC and the facts of this are published in the official gazette. Winding up means a closing up of a LLP's concern, which may be reason of insolvency or otherwise, by the realization of its assets, payments of liabilities, and distribution of surplus, if any, amongst the partners of LLP. The Act and the rules provide the process and regulates the process of winding up of the LLPs. As per Section 63, 64, and 65 of the LLP Act, the winding up process is mentioned. There were another set of rules which were notified on 10th of July 2012, which are LLP Winding Up and Dissolution Rules 2012. These rules are divided in 6 parts, namely Part 1 is its introduction, Part 2 is its modes of winding up, Part 3 mentions about the voluntary winding up, Part 4 mentions about the winding up by the tribunal, Part 5 provisions applicable to every mode of winding up, which are the common provisions, and Part 6 is proceedings and procedures general. Here I would be covering modes of winding up, voluntary winding up, and winding up by the tribunal. Insolvency and Bankruptcy Code 2016 regulates the process of voluntary liquidation under Section 59. Before moving on to the process of winding up, here we'll see 3 terms which are commonly used in the rules. First is the liquidator. A liquidator means a person or liquidator appointed in connection with the voluntary winding up, or it is also appointed in winding up under tribunal from the panel maintained by the central government. In this panel, names of practicing company secretaries, practicing chartered accountants, advocates, practicing cost and works accountants are mentioned, from where the liquidators are appointed. The other term is officer. Officer includes any designated partner, employee of the LLP, and any person in accordance with those whose directions or instruction the partner of the LLP have been accustomed to act. The other important term is tribunal. Tribunal here means under the Act, National Company Law Tribunal, which we all are very well aware of. Next, moving to the distinction between winding up and dissolution. As we all know, winding up is a process which brings an end to the life of an LLP. After paying off to its creditors, and the proceeds are realized after selling off its assets. Whereas dissolution is the last stage of winding up a process. After many legal compliances, the liquidator applies to the court for dissolution. The order of the dissolution is then filed with the registrar. And finally, the LLP is dissolved. Under winding up, which is a long process, during the winding up and prior to the dissolution, the legal existence of the LLP continues. It can be sued by another parties in the court of law. In dissolution, the entity comes to an end and its legal existence is closed down, which is recorded by the registrar and mentioned in and is published in the official gazette.
Yes, Harshita, as you rightly said, the winding up is actually the process which undergo with meeting all the legal obligations and paying up the creditors and liabilities, meeting everything. And ultimately, you are left out only with the net assets distribution, which is amongst the partners. That is the last stage of the winding up, which is actually coming to it. And once the winding up gets over, then the dissolution of the firm actually starts, then that is the end of the flow. Then
Yes.
ultimately ROC strikes down the name of the LLP. Yeah.
Mr. Anwar has raised the hand. IT department, allow Mr. Anwar to speak, please. Mr. Anwar, you can unmute and speak. Mr. Anwar? I think by mistake he done it. I'll request, we'll connect the as regards speaking permission at the end of the session. That will allow us to do that. Okay? So I'll request participants to raise hands later on, please, at the end of the session. Yeah, Harshita, carry on, please.
Yes, ma'am. Now we are moving on to the modes of winding up of LLP. Under the Act, LLPs could be wound up by voluntarily by decision of the partners or winding up by the tribunal, which is also known as compulsorily winding up. The provisions are also given under the IBC code, that is Insolvency and Bankruptcy Code 2016, which defines the wounding up of the corporate persons. Under the code, corporate persons are defined as a company registered under the Companies Act 2013 or Companies Act 1956. As well, it also includes LLP registered under LLP Act 2008. So the LLP could also be wound up under the provisions of IBC code. According to Section 59 of the IBC code, any corporate person, that is here in our case LLP, who intends to liquidate itself voluntarily and meets the conditions prescribed in the code may go for winding up under the IBC code.
That means one thing is very clear here, Harshita.
Yes.
The LLP, which is actually a limited liability partnership, which are actually incorporated registered on the company side, can actually go through the IBC code. But whereas the limited liability partnership, which was the Partnership Act 1932, which was there, which cannot be applicable to the IBC code. Am I correct?
Yes, sir.
Harshita, the participant has said that please go slow. So if you don't mind, just last portion you repeat slowly.
Okay, ma'am. Shall I repeat the last portion?
Yeah. Yes,
Yeah.
please.
Yes. As per Section 59, I stated that there are provisions for voluntarily winding up under the Insolvency and Bankruptcy Code 2016. According to this code, a corporate person who intends to liquidate itself voluntarily and meets the conditions as mentioned under the code may initiate voluntary liquidation under the code, that is IBC code 2016. Moving on to the circumstances of voluntarily winding up of LLP, which are under the rules of LLP.
Harshita, no, you mean to say that LLP can also be voluntarily wind up under the IBC, and LLP can also be wound up under the IBC by tribunal, right? That is the point we are talking, like a company.
Yes, ma'am, like a company.
Yeah. Please, now you go.
The circumstances mentioned under voluntary winding up of LLP. LLP may be wound up voluntarily in following cases. There are two cases: voluntary winding up by the partners and voluntarily winding up by the creditors. So, a voluntarily winding up by the partners is where the partners decide to wind up the affairs of the LLP voluntarily on mutual agreements between them and as per any grounds provided under the LLP Act. For the approval of the resolution to be passed for voluntarily winding up, three-fourths of the total number of its partners' approval is required. And where the voluntary winding up is by the creditors shall be, they can be either secured creditors or unsecured creditors, and the creditors are of the opinion that the LLP may not be able to fulfill and pay its liabilities to continue its business. The LLP then shall convene the meeting of its creditors to allow them to consider the proposal by the partners, and then they can consent on the proposal put before them. Approval of creditors is a must for winding up of the LLP, even if they are going for voluntarily winding up.
When you are talking about the voluntary winding out, it is actually one of the prerequisites that the LLP should be solvent, which means they are able to meet all the debts in full and discharge the liability totality. That is the prerequisite there when you are talking about the voluntary winding up by the partners, because they are actually supposed to declare the solvency and they'll have to also give a declaration that they are able to meet all the debts and liabilities and other things. That is one of the prerequisites for a voluntary winding up. Chetan, you would like to add anything on this?
No, I think whatever you have covered, that is absolutely correct, because the process which is given under the LLP Act also and the section 59 of the IBC code also, that is more or less is same. That is based on the declaration. If the company is solvent, only in that case the voluntary winding up can be there. I think this is correct. Understand?
And whether, Chetan bhai, if the resolution is not there and you give consent of all that before majority is okay, or you need resolution format only to NCLT?
Both ways that can be done. You can you can take a written consent from all the 100% shareholders, or you can have a one meeting of the partners and you can pass a resolutions for winding up. That resolution can be as a support to initiate the voluntary liquidation.
So if resolution, then 3/4, and if you take consent, then 100%. That is the way?
Yes. If the consent is there, then the 100%. Otherwise, the approval, because that can be 3/4.
Oh, this is very important thing. If a resolution you pass, then it is 3/4. If you take consent, then it is 100% or voluntary.
And
Yeah.
also, I think there is a provision is there. If there is any defraud of any person, etc., and all the things, the voluntary winding up can never be taken up.
Yes. That is there.
There is a question: NOC in voluntary winding up only of secured creditors?
That is for voluntary liquidation. There is no creditor consent is there, na? The voluntary winding up by the creditors also.
No, because we have written no voluntary winding up by creditors, then LLP should convey the meeting of its creditors to allow them to consider proposal.
Correct.
And creditors are of the opinion that may not be able to fulfill pay and continue with the business. Now, this is voluntary winding up by creditors. That's why the people are confused, I think, Chetan bhai, that whether it is through NCLT route or by itself, like shareholder pass the resolution and that is that.
No. For voluntary liquidation, for voluntary winding up under the LLP also, they have to approach to the NCLT. That is by the tribunal.
So second portion, Harshita, you are taking is a winding up by creditors, compulsory winding up. by creditors under NCLT route, right? This
Yes, right.
that's correct.
For the section 64 subsection C under the LLP Act, that gives for in case the company is not able to pay the debt, that is compulsory shifted to
I can
IBC.
understand the participant got confused when you are writing voluntary winding up by creditors. So it is, okay, that's why people are asking whether there is a threshold limit or anything. So that's why, friends, this is first point is voluntary winding up by the partners. Second is under that winding up by creditors when the company is unable to pay its debts. First is financially sound. Second is not financially. Liquidity is the issue.
Harshita, somebody has put a question. Can you actually repeat the point of 100% consent and 3/4 approval?
I will say that Chetan, you can put it there. It is your point.
Yeah. No, not an issue. In case when we are going for a voluntary winding up by the partners, if we are calling a partners meeting, then there is a 3/4 consent, 3/4 majority is required in order to pass the resolution, that is to initiate the voluntary winding up. And in case if the partner is not having any meeting, so they can, with the 100% of the partners, all the partners will give their consent or affidavit. They are confirming their consent for voluntary winding up. So that is a difference for approval by a 3/4, or if you are giving through a consent, so then the 100% member should give their consent.
Yeah, and again the question is coming that voluntary winding up by creditors, friends, again I'm telling it is a creditors compulsory taking you in the winding up, and it is through NCLT route. First is partners. There is a confusion because it is written voluntary binding up by creditors. You can take it as binding up by creditors, no voluntary. It's a binding up by creditors. And there it is under governed by IDC and all that. So that is the clarification we are taking. And she is covering the process. Chetan, you would like to say about that winding up by creditors, these 3 points?
Somebody has put up a question again here, whether the voluntary winding up by the creditor, whether the LLB should be solvent.
That's why only I'm telling again that please solvency is a voluntary winding up by partners. And if financially or liquidity is not a problem, not solvent, then it is winding up by creditors. Harshita, it should not be voluntary. People are confused literally.
Yeah,
Please,
absolutely, you are right, Dipti, because when it is actually solvent, when the partners want to wind up, by giving an undertaking, they will discharge all the liabilities in full and they will meet all the debts, etc. and other things, therefore, for the voluntary winding up.
Yeah.
But when it's come to the creditors, whether it is a secured creditor, unsecured creditor, whatever it is, if the creditors feels that LLB is not able to meet their liabilities, if that is the thing, because their interest is actually affected, then they go for winding up process, which is actually termed here as the voluntary winding up, because creditors voluntarily take up this winding up process because they think their interest is actually affected, they will not be able to realize the debts. So since they are initiating the action voluntarily, that is why it is voluntary here.
Yeah. But we will not confuse now anymore, no more time. But the thing that Chetan on the process, I'm confirming again, financially sound, voluntary winding up by partners, first portion, financially not sound, it is winding up by creditors, second portion. Chetan, your comment on that process.
Just to give you, I think
1, 2, 3 topic, no, like here the consent in that winding up by creditors. This topic may not be able to fulfill the convey the meeting of creditors and approval of creditors. So here, whether this again the meeting of creditors and what will be the consent portion, or whether only consent will do, or here also again if you can give throw light on the meeting or the consent, whether it will do for this voluntary winding up by creditor or binding up.
Just to add, ma'am, whatever because this terminology, I think the Harshita has taken from the Act only.
Act only, I know.
Yes. So that's why there is a confusion. But whenever there is the LLP is not able to pay its liability, so that portion itself is to be taken under the Insolvency and Bankruptcy Code only. The LLP Act will not deal with this situation when the LLP is not able to pay its debt. So that is entirely goes to the IBC provision, and under the IBC provision there is a section 7, section 9, whatever be the in case of a default, because they will not even take for a section 59 also for voluntary liquidation, because the voluntary liquidation under IBC also there is a must the company is a solvent, then only section 59 route is available. Otherwise, they have to take a route of section 7, section 9, section 10, whatever be the scenario for dissolution. The entire CIRP process is required to be done.
We are covering that entire process later on, so we are not commenting at present. There is a question: what if there are only 2-3 partners, my dear? Even though 2-3 partners, either you take consent of 100% for voluntary winding up, or take a resolution in 3/4.
Yes, yes.
In case of creditor initiate an action due to non-payment or failure to pay the dues or interest, how will it be voluntary? We mentioned that this is the word taken from the law. It is not taken by Harshita herself. I have mentioned Harshita because I know that she has to clarify it. As per law, it is mentioned that way. So it is taken, but please understand this way. So we clarified that. Okay. And if loan from partner is covered under creditor, second question is, LLP is not able to repay partner's loan, then can the partner take the winding up by creditors? Chetan bhai.
No. If the LLP is having a loan from a partner and the partner is the LLP is not able to repay that loan, they cannot go for a winding up under the IBC also. IBC, I think section 10 can be filed for.
Section 10, but that also section 10 as a partner because it has defaulted. So as a LLP, they can go by itself because there is actually a default.
Yes, the LLP has to move an application under section 10.
Yeah. Like IBC, we say, no, in IBC, it is like creditors or section 7, 9, and 10. Same way you have to cover here. So section 10 will be there. That is, section 10 says that the company or LLP itself can file the application for liquidity insolvency. And under that, LLP can do it because there is a default. There is also a question that what is the, I think we are covering later on about the monetary limit.
Yeah, that we are covering later. Yeah.
So Harshita, now, CS, now you can move to second slide and go ahead.
Okay.
Thank you.
The next is the process of voluntarily winding up. The same process is followed under the IBC code. There are around 10 steps to follow for voluntary winding up, which includes commencement of liquidation, appointment of liquidator, public announcements, verification of claims, realization of assets, distribution of proceeds, liquidation report, submission of final report, passing of dissolution order, and finally filing the order with ROC. We'll now see one by one what all these steps include. Commencement of voluntary winding up and filing up of statement of affairs. The first is the obtaining declaration of solvency. For voluntary winding up, it is a must that the LLP must be solvent. For this, declaration of solvency is obtained from the partners, which also have some documents which are to be attached along with it. A declaration of solvency verified by an affidavit has to be obtained from majority of designated partners of LLP. Along with it, the declaration of solvency shall accompany by the audited financial statements and records of business operations, and it shall have a report of valuation of the assets of the company, LLP. The declaration made under this rule shall be delivered to the registrar for registration within 15 days immediately preceding the date of passing of the resolution for winding up of LLP. It contains a statement declaring that LLP is not being wound up to defraud any person or person. And as I've stated, it is also accompanied by a statement of assets and liabilities. time period for which these statement of assets and liabilities are mentioned in the provisions. And it is also accompanied by a report of valuation, which is prepared by a registered valuer for the assets of the LLP. From here, the winding up process starts. It is from the winding up process is commenced from the date of passing of the resolution. Next step is appointment of liquidator. As soon as the resolution is passed by the designated partners under the voluntary liquidation process, the appointment of liquidator comes to a must. The LLP shall, within period of 30 days of passing of the resolution, where LLP has no creditors, or filing of the notice intimating decision of winding up in case the LLP has creditors, shall appoint a liquidator with the consent of the majority of partners for the purpose of winding up of the affairs of the LLP. Again, the majority of creditors shall approve the appointment of the liquidator. The appointment of the liquidator will include all the appointment terms, and his remuneration will be decided here by the designated partners. In case if the creditors and the partners of the LLP nominate different LLP liquidators, then the LLP liquidator nominated by creditors shall be the LLP liquidator. But where the creditors neither approve the LLP liquidator nominated by the partners of the LLP nor nominate any other LLP liquidator, the LLP liquidator, which will be nominated by the partners, will become the LLP liquidator for the winding up process. Where filling of vacancy of LLP liquidator. In case where the vacancy has been created due to death, resignation, or removal of LLP liquidator, then the vacancy will be filled by the partners. The notice of the appointment of LLP liquidator will be given to registrar in case of any appointment or change in the LLP liquidator, indicating his name and particulars of the LLP liquidator, and it shall be filed with registrar within 10 days from such appointment or change. And the form number is given as form number 7 has to be filed with the registrar. Once the LLP liquidator has been appointed, the designated partners and other partners' power cease, and all the powers are given to the LLP liquidator. There are few cases where the LLP liquidator can be removed and replaced. The process is undertaken by the tribunal. In case of any vacancy in the office of the liquidator, it shall be the duty of the tribunal to get another liquidator appointed here. There are few conditions given where the removal and replacement of liquidator may happen. Tribunal believes that any liquidator under this rule is responsible for causing any loss or damage to the LLP due to fraud, misfeasance, or failure to exercise due diligence and due care in the performance of his powers and functions. Then the tribunal may remove LLP liquidator appointed for the winding up process. Any order may be passed by the tribunal as it may deem fit that the LLP liquidator has to be changed. Then the tribunal may pass an order for the same purpose. Then there are duties of LLP liquidator. Some of the duties are mentioned in the LLP rules for winding up and dissolution, which provides what all types of duties the liquidator shall carry on for successful winding up process. First is perform such functions and discharge such duties as are determined from time to time by the LLP or its creditors, as the case may be. Second, LLP liquidator shall obtain approval of partners or creditors of partners, as the case may be, for any purpose he may consider is necessary, where the LLP liquidator feels that some prior approval from the partners and creditors are required, then he may go to the partners or creditors for the same. Then LLP liquidator shall maintain regular and proper books of accounts in the form and manner as are specified in the said rules, and the partners or the creditors or any officer authorized by the central government may inspect such books of accounts. Next one is the LLP liquidator shall settle the list of creditors or partners which shall be prima facie evidence of the liability of the persons named therein to be creditors or partners. It is one of the duty of the LLP liquidator to settle down the claims which are received while winding up of process, and it's included in his duties to settle these claims. Then it is very important for LLP liquidator to observe due care and diligence while discharging his duties, and no misconduct shall happen from his side. The next duty of the LLP liquidator includes the paying of the debts of the LLP and shall adjust the rights of the partners amongst themselves. These were the few duties which were mentioned in the rules of LLP liquidation rules. Next, there's a provision also given for meeting of creditors. Here, if LLP has creditors, whether secured or otherwise, there shall be approval shall be received. It is in the case where the LLP is not solvent. The copy of declaration along with the estimated amount of the claims due to each of the creditors and offer for creditors to accept such claims shall be sent to creditors by registered or speed post or any other mode. Then the creditors shall give to the LLP their opinion on voluntary winding up proposed by LLP or their acceptance of the offer made. This shall be communicated within 30 days of the declaration. The LLP creditors shall give their consent whether and give their opinion whether the proposal is in their interest and the interest of the LLP. They shall also see that whether the LLP can pay off its debts from and their claims can be realized from the selling of the assets in the process of winding up. The LLP will not be able to pay for its debts in full form of the proceeds and propose that it will be in interest of all the partners. Then LLP shall within period of 14 days thereafter file an application before the tribunal for winding up. After the approval from
Basically, Chetan back. Just I will put it and you can add it. There are people are confused also, so we will make it what is voluntary winding up of a company with creditors when they are financially sound. Then there is a winding up of LLP either by LLP itself or by creditors. The concept will clarify so that this confusion on the process will not be there when they are not financially sound. So take the condition when LLP is financially sound. It can be all extent. Then you pass the resolution of partner with 3/4 majority or take a consent 100% of partner.
Yes, ma'am.
And straight we start the process of voluntary winding up and you file for dissolution in NCL. Now came the situation that company is financially sound, but it has not complete amount to pay to creditors. Now the partner wants to voluntarily wind up. In that scenario, whether you can pass the resolution, but you will require the consent of creditors also. Because if voluntary winding up, you have to pay all the creditors.
Yes.
And then only you can go for dissolution. Now you decided for voluntary winding up, you have creditors, but you don't have sufficient fund to pay creditors, but still you want to close. Then you can go to creditors, take their consent or NOC or kind of thing, and still you can yourself as a LLP wound up voluntary. So this is entirely the process in broader concept of voluntary winding up of LLP by the management or the partner. Correct, Chetan? This is the condition. Now we see the situation. So that's why we are telling voluntary winding up by or LLP by LLP. Now come the situation that company LLP is not financially sound and the creditors are taking it into insolvency. There it will be totally first filing point will be to IBC, to the NCL. Participant, it is clear. In the first part, LLP itself decides to close it. It has to be financially sound. And even if creditors, you have to take NOC, even if financially sound. And then you yourself decide, complete, sell the asset, realize, pay all creditors, and go for dissolution. Now you are again voluntarily deciding that I want to close it, LLP itself. But they don't have sufficient fund to pay to creditors. Then you have to go again to the creditors and get the consent. In both the places, consent is required. And you take NOC and then you realize asset, pay asset or whatever available to the creditors. They have already given NOC and then you go for default. This is the voluntary winding. But when there is a default and all that, there is a creditors winding up which is set. Clear? I hope so. And you are covering voluntary winding up at present, right, Harshita?
Yes, ma'am.
Yeah, Chetan bhai, if you want to comment. Because there are questions coming regularly, that's why I'm clarifying this.
नहीं मैम, just on a practical aspects, मतलब whenever the LLP is doing business on a just on a practical side, if the LLP is solvent, they are able to pay all its debt, so they have an option. They can go under the LLP Act also, and they can go under the IBC also. If in case if there is the solvency is not there, they are not unable to pay the debt, they can go under the matlab the advisory is to go under the IBC only, because the provision for insolvent that has been migrated as per the amendment to the IBC only. So as per IBC, there is all the situations are covered, whether section 7, 9, 10, 59. Matlab in case of a insolvent, it is better to go with the IBC side if the LLP are not solvent. That is just advice.
Chetan, if I'm not mistaken,
Yes.
I've seen in the companies, but I don't have the experience of the LLP. Even if the voluntarily, if you want to wind up, if in case of the company I'm talking, I hope that will be the same in case of the LLP as well. If the LLP has got a creditors, either secured or unsecured, even if you want to go for the voluntarily winding up when the company is actually solvent, the LLP is solvent, even then you will have to call the creditors meeting and
100%.
get their approval for the winding up by getting the 3/4 majority.
Because
Is that correct?
Yes. Because the voluntary liquidation means with the consent of all the stakeholders,
Yeah.
including creditors, unsecured, secured, or members.
Yeah. So just because you are solvent, I'm able to pay the thing, and you cannot get rid of the creditors meeting.
No. Yes.
That is 100%. It is there actually.
Yes.
But only cases in Companies Act also there was a provision, circumstances in which you can actually seek for the exemption of the creditors meeting or something under some specific ground. But LLB also you know to take the consent of the creditors as well, even if you are solvent, if you are going for the voluntary winding up.
For all the cases, if the company is having the creditors, the consent of the creditor is a must.
Yeah,
matlab.
that is right.
For
but
all
as Dipti has puts it, when the company is not solvent, then they cannot go for the voluntary winding up. Because voluntary winding up is possible only the prerequisite if the company is actually solvent and they are able to give a declaration with the solvency, they are able to meet all the debts and they can meet all the liabilities.
Yeah.
Am I correct?
So इसमें actually में act में there is a provision, because of that the confusion is arising.
Yeah.
There is a voluntary winding up in case the company is not able to pay its debt under the LLP Act.
Hmm.
But as per my view, that if the LLP is not able to pay its debt, then they have to go to the IBC only.
They are telling that if, like in Companies Act, if company voluntary want to do that and they are not able to give all the payment to the creditors, they can take NOC and then do it or kind of thing. But it is financially sound. Let's clarify: financially sound, voluntary winding up; financially not sound, under IBC.
Yes,
Correct.
that's the thumb rule.
That is the correct position, Dipti, you said it.
Only thing that if creditors take the consent, even though you are going financially sound, because that is pending.
Yes, yes, yes.
And best practical way we say that you pay all creditors, no? So then there is no creditors, then you go your way.
Ha, correct.
Best way is that.
Yes.
You decide after paying, otherwise also later on you have to pay.
Definitely.
You will able to bargain with the creditors, because the liquidator will not able to bargain. They have to pay whatever it is.
For voluntary liquidation, just to give you the practical insight, when we are going for a voluntary liquidation, whether under the Companies Act or under the LLP in IBC, all the creditors has been paid before the commencement of liquidation. So that there will not be any consent required or the procedure got delayed because of anything, because it is a voluntary thing. So you can settle with the creditor before commencement of liquidation.
Yeah.
Somebody has put up a question here. Creditors must include statutory authorities. Do you require NOC in writing from them?
No, for whatever be the creditors are there in your balance sheet, in your statement of asset and liabilities, that should be square off before liquidation. And you have to give under the IBC, the advertisement and anything, if there is any claim received, then the liquidator is responsible to address before distribution. There is no concept of NOC as such. Earlier there was a NOC from the income tax is required, but in 2022 there is an amendment under the IBC which done away with the requirement of obtaining NOC from income tax authority, so they can go without NOC.
But I think in all the act there is a provision is there. Before they actually distribute anything, the first thing is all the statutory obligation has to be met.
Yeah, definitely. For a volunteering thing, if there is any demand, so you have to that is a responsibility of the liquidator to ensure there should not be any demand from any authority pending before distribution of the funds to the shareholder or a partner.
Basically, you have to intimate all authorities, and they have been given time. So intimation, and if they don't revert newspaper advertisement, if they don't file the claim, you are okay with that. That is the requirement.
Yes, that is a process that we are following.
So again, friends, I am telling financially sound, voluntary winding up, by partner. You take creditors NOC because they are unpaid, even though financially sound. If not financially sound, go to NCL. Clear? And we are taking at present voluntary winding up.
Somebody has put up a question. Why liquidator is required in case of the solvent LLP without any debtor or creditor?
IBC requirement.
The liquidator is a must thing. That is a legal requirement that should be because that is an independent position that somebody has to see whether the complete process is adhered or not. Before IBC also the liquidator role is there. And after IBC also there is a lot of responsibility on the liquidator. That is must required.
Yeah, you are absolutely.
Because it is declaration by partners, but we have to check that the process is actually the company. There is no fraud. There is nothing wrong thing. Advertisement is done. Claim is seen. And proper process of receipt payment is done. It is audited. That are many things in closures issues. Even though it is passed by the partners, even though creditors give NOC, there can be various issues. The company is run, so there has to be neutral person, professional to carry on this.
Yeah, you are actually right. When the liquidator is appointed, what happens is all the partners' powers comes to an end actually. The management is actually taken over by the liquidator, as you rightly say, directly under the supervision of the tribunal whom he reports actually. So he has to ensure everything is all right, verify and do the thing. That is where it is there. Law requires this position, and it is the requirement of the legal requirement, as Mr. Chetan puts it. Yeah.
Go ahead, please.
Yes, ma'am. Thank you, ma'am and sir, for the clarification. The next step is publication of resolution to wind up voluntarily. Once the resolution is passed by the partners, that approval for winding up has been approved. The next step is to give notice of the resolution for winding up by advertisement in a newspaper, circulating in the district where the registered office or the principal office of the LLP is situated. Newspaper advertisement will be given in one English newspaper and one regional language newspaper, which is widely circulated in that district. The newspaper advertisement shall be given within 14 days of the receipt of the creditor's consent. The effect of this winding up process will be that the winding up business will be the business will be stopped, and the corporate person shall cease to carry on its business from the date of the resolution has been passed, but the existence of the LLP will still continue. Next is application to tribunal. Once the period of 14 days of the publication of advertisement has been completed, the liquidator will file for the application to the tribunal. The last stage of the voluntary winding up is dissolution of LLP. The LLP liquidator will now prepare a report stating the detailed explanation of the procedure followed during the winding up in the prescribed form that is given under the rules. He shall thereafter seek approval of the partners and creditors of the LLP. The approval may be sought through circulation, which can be either in electronic form or in physical form. After the report is approved, then it shall be within period of 30 days. In case the requisite amount of partners or creditors are not able to decide on the approval of the report, then the liquidator shall make an application to the tribunal to determine the issue, and the order by the tribunal shall be passed in this matter, and it shall be binding on all the partners. Within 15 days after the resolution of the approval of the report has been passed, the liquidator shall send the same to the registrar, a copy of the final winding up of accounts, explanation, and report. The form which is specified here is form number 10, and file an application with tribunal along with a copy of the final winding up accounts, explanations, and reports for passing an order of dissolution of the limited liability partnership. If the tribunal, after receiving this copy, is satisfied that the process has been duly followed, then it may pass an order within 60 days of receipt of such application, and after passing of the order, the LLP will stand dissolved. The liquidator shall then file the order of the tribunal with the registrar within period of 30 days once this order is received. Thereafter, the registrar shall publish this order in the official gazette, and finally the LLP will stand dissolved under this voluntary winding up process. If the affairs of the LLP are not fully wound up within a period of 1 year from the date of commencement of voluntary winding up, the LLP liquidator shall file an application before the tribunal explaining the reasons therefore and seek their appropriate directions thereafter.
There is one question has actually come here. I think this is Anil Jain has put some. Shall appreciate dissolution process for the LLP having only partners' contribution or partners known for a long time. Application to tribunal can also be by a partner. Then what will be the liquidator do? What is the liquidator's qualification, etc.?
Yes, Chetan, you would like to comment?
I think Mr. Chetan could answer, but he is in mute, I think.
Okay, basically, see, again, I'm telling you, that like if company, I will help ask you that way, that in company shareholders part do resolution and then still you appoint a liquidator. I explained that we need a liquidator. It is a legal requirement. Same way in LLP. Yeah, Chetan bhai, you want to, I'm just answering since you are not there. That's the same way in LLP, partners decide to dissolve, so wind up voluntarily. Still liquidator is required. And even the partner loan is there for long time. It is a debt to the LLP. Chetan bhai, that question is that dissolution process for the LLP having only partners contribution or partners loan for long time. Application to tribunal can also be by partner. Then what will be the liquidator do? Liquidator clarification. It is a legal requirement once and all, I will say that way. You
No,
can't
no,
keep on telling.
definitely, ma'am. There is a confusion, यानी कि I believe the participants have seen कि भी हमारा पैसा है, हमें आपस में डिस्ट्रीब्यूट करना है, तो why need liquidator? एक्चुअली में ना जो प्रोसेस है वो स्ट्राइक ऑफ का डिफरेंट प्रोसेस है। वो मतलब स्ट्राइक ऑफ के साथ कंफ्यूज हो जाते हैं कि भी स्ट्राइक ऑफ इज द इजीएस्ट प्रोसेस कि भी उसके थ्रू आप एलएलपी को वाइंड अप कर सकते हो लेकिन स्ट्राइक ऑफ में डिफरेंट सर्कमस्टांसेस है व्हेन देयर इज अ no operation in the company and there is a no assets in the company and no liability is there, only the capital and the loss is there, the nil balance sheet is there, then you can straightforward without any liquidator you can go for a strike off. In case of a liquidation, the basically the intent of the lawmaker, I think so कि भी somebody has there to check before giving any dissolution कि whether the complete process has been followed and whether there is any due from any statutory authority or at a public at large, because it is a small company or a private company, you cannot take that advantage कि भी हमने decide किया और हमने अपने आपस में ही कर लिया, लेकिन पब्लिक एट लार्ज को आपको इन्वॉल्व करके ही गवर्नमेंट का ये इंटेंट है, क्योंकि डिसोल्यूशन इज अ काइंड ऑफ अ थिंग, देन यू गेट अ परमानेंट थिंग्स ऑन रोल, that the permanent death of the corporate is there. But in case of a strike off, that is a temporary. That's why, matlab for winding up, they has to double assure before giving the dissolution order कि मतलब the proper opportunity has been given to a public at large, including government authorities.
Okay. Thanks. Let's go ahead.
Yes, ma'am. Next, we come up to the winding up by the tribunal.
1 minute. There is a raising of hand by Miss Pooja and Mr. Ravi. IT department, allow them to say Miss Pooja first. IT department, yeah, Miss Pooja, you can unmute and talk. Okay. I think by mistake. Yeah, sorry, go ahead.
Okay. The next is winding up by the tribunal. The winding up by the tribunal is the case where the tribunal passes an order for the winding up of the LLP. There are certain circumstances which are mentioned under the rules. First, we'll look out for the steps. There are around 5 steps which we follow for winding up by the tribunal. First is the petition for winding up. Then next is appointment of LLP liquidator. Then finalization of liquidation and approvals are received. Then dissolution of LLP, and then filing of necessary forms with the regulatory authority. So coming to the circumstances in which limited liability partnership may be wound up by tribunal, there are 5 points that are given. The circumstances are given under the rules. The first is if the limited liability partnership decides to be wound up, it may go to the tribunal. If the number of partners have reduced below 2 for a period of more than 6 months, if the LLP has acted against the interest of the sovereignty and integrity of India, the security of the state or public order. Next is if the LLP has made a default in filing with the registrar the statement of accounts and solvency or annual report for any 5 consecutive years, or the tribunal is of the opinion that it is just and equitable that the LLP would be wound up. The provisions for compulsory winding up are given under Section 64 of the LLP Act, and the circumstances are given under the LLP Winding Up and Dissolution Rules 2012. The case where the LLP is unable to pay its debts, an LLP shall be deemed to be unable to pay its debts if a creditor to whom the LLP is indebted for an amount exceeding 1 lakh rupees then due has served on the LLP a demand requiring the LLP to pay the amount so due, and the LLP has failed to pay such amount within 21 days after the receipt of such amount, or to provide adequate security or restructure or compound the debt to the reasonable satisfaction of the creditor. Any execution or other process issued on a decree or order of any court or tribunal in favor of a creditor of the LLP is returned unsatisfied in whole or in part, or it is proved to the satisfaction of the tribunal that the LLP is unable to pay its debts, and in determining whether a LLP is unable to pay its debts, the tribunal shall take into account the contingent and prospective liabilities of the LLP. It is a case where LLP is unable to pay its debts.
Now, it is under this IBC what we are talking, where the LLP is unable to pay debts. And please note that here the default is must. Chetan bhai, you would like to comment? It is only 1 lakh. That original amount is there. For company, it is 1 crore. Yeah, Chetan bhai.
Ma'am, basically under the LLP Act, it is 1 lakh. So that's where the confusion. Under the LLP Act, there is no amendment, but however, under the IBC, they have increased that amount.
Yeah. So what it will be, 1 lakh or 1 crore?
No, if we are going under the LLP Act, matlab unable to pay its that should be 1 crore only, because that is a provision under the IBC. Because you cannot do in case of insolvent, you cannot do under the LLP Act.
Yeah. Okay. Yeah.
That is my,
Yeah, please.
Okay. Next is the petition for winding up. The petition for winding up may be presented to the tribunal by LLP or any of its partner or partners, by any secured creditor or creditors, including any contingent or prospective creditors, by the registrar itself, or by any other authorized person by the central government, by the central government in case falling under Section 51 of the Act, LLP Act, and by the central government or a state government in case falling under Section 64. These are the people who may file petition for an LLP winding up. After filing of there are some powers of the tribunal which are mentioned under the LLP rules. The tribunal may dismiss the petition with or without cause after scrutinizing the petition. It may make an interim order as it thinks fit after scrutinizing the petition. The direction for revival.
Ms. Jinal has asked again.
Yeah,
Ms.
somebody is
Jinal,
asking, Jinay is asking, can I ask a
IT
question?
department, just allow Ms. Jinal to speak. Yeah, you can unmute and do that. Ms. Jinal.
Yes, Jinay Joshi, you can speak.
Good afternoon, sir.
Yes.
Hello. Am I audible?
Yeah, we can hear you.
So my question was unable to pay debt. Can you please get that site?
The background voice is coming. I don't know from where it is coming.
Echo is coming. It's not clear, your voice.
Wait a second. I will just disconnect my Bluetooth.
I think she's saying basically that
So my
if
question, can we go to unable to pay debts one side? Can we link this to by voluntary winding up by the creditors? This reason can be used?
Sorry.
Hello.
Hello, what is your question exactly?
Yes. My question is, this inability to pay debts, can we use this reason by the voluntary winding up by the creditors?
Chetan,
You are saying
Yeah.
the LL.
yeah.
You are saying that the LLP is not.
Balaji.
Okay, okay.
No, I'm just, I think Balaji also repeating the questions. So same is with me. If the company is unable to pay its debt, can the LLP can be wound up by the creditor consent under the LLP Act, you are saying?
Yes. I'm saying about the LLP only.
No, that LLP Act, if there was an amendment, if the LLP is unable to pay its debt, then they have to go under the IBC only.
Okay.
So they
So
have
they
to
can't
approach
do the voluntary winding up by the creditors under LLP Act.
under the LLP Act if they are not able to pay its debt. If the LLP is solvent, they can definitely go under the LLP. They have a choice to go under the LLP Act or under the IBC. But if they are not able to pay its debt, then compulsorily under the IBC.
Okay. But if they are not able to, the creditors have to prove that the LLP is not able to carry the business. So can these points be used?
No.
See, Jinal, the question is, even if some of the creditors feel the LLB is not able to pay the debts, still
Yeah.
they have to call the creditors meeting. 2/3 of the creditors have to vote for it. If 2/3 of the people actually are the opinion that the LLB is not able to pay its debit, then automatically it will go for the winding up.
Okay. Got
Because
it.
the
And
2/3 special resolution is required, na?
Yes. Got it.
Unless you get the 2/3 resolution consent by
Yes.
calling the creditors meeting, thing cannot move forward.
Okay.
Chetan, you want to comment further?
No, just to add, Bala sir, basically, if even with the consent of the creditor also, I believe if the LLP is not able to pay its debt, then definitely that will go under the IBC only.
Correct. You are right.
Oh.
If you are not able to pay, very clear it is, as Chetan puts it very clearly. If you are solvency, fine, LLP Act. If it is not solvent, if you are actually not able to pay, naturally IBC will be revoked.
Correct.
Okay.
Yes, Jina. I hope I answered your.
Yes. I'm clear. Thank you.
Okay. Harshita, I think you can continue.
Yes, there are certain powers of tribunal which are given under the rules. First is the tribunal may dismiss the petition with or without costs. It may make an interim order as it thinks fit. The revival or rehabilitation of the limited liability partnership may also be ordered by the tribunal under section 60 and 62 of the LLP Act. Um, a liquidator may be appointed as provisional liquidator for LLP till the making of a winding up order. It may make an order for the winding up LLP with or without cost, and any other order may be passed by tribunal as it may consider fit. Then, filing of petition by any other person other than LLP. If the tribunal shall satisfy that a prima facie case for winding up of the LLP is made out by an order, it may direct LLP to file its objections along with a statement of its affairs in the form and the manner which is specified in the rules. The LLP which fails to file the statement of affairs as mentioned in the above case, then they shall forfeit the right to oppose the petition of winding up. The partners and other officers of the LLP who or have been responsible for the maintenance of accounts and their audit shall ensure that the accounts of the LLP in respect of which petition for winding up is made are completed and audited in accordance with the rules and are up to date of the winding up of the order and are submitted to the tribunal at the cost of LLP. Such statements of affairs are to be in the format which are specified under the rules within 21 days from the relevant date for which such extended time, not extending 2 months, as the liquidator or the provisional liquidator or the tribunal may, for special reason, extend them to file these statements. Next is winding up order to be communicated to the liquidator and the registrar. Where the tribunal has made an order for the winding up of LLP, it shall cause such order to be sent to the regulator and to the registrar in form number 12, which are specified under the rules, within a period of 15 days from the passing of such order. It shall be the duty of the LLP then and the petitioner to file the certified copy of such order within a period of 15 days from the date of making of such order. Under these rules, it is provided that the winding up order shall be deemed to be a notice of discharge to the officers, employees, and workmen of the LLP, except when the business of the LLP is continued. The business from here shall be stopped and the LLP order for winding up has been passed. It is provided that the order of winding up of an LLP shall operate in favor of all creditors and all the partners. There are jurisdiction of tribunal is also mentioned under the LLP rules. The tribunal have the following jurisdiction over the following matters. It has a jurisdiction over any suit or proceeding by or against the LLP, any claim made by or against the LLP, including claims by or against any of its branches in India, any application made under section 62 to 60 of the Act, any scheme submitted under the Act or any other law for the time being in force for revival and rehabilitation of LLP, any question of priorities or any other question whatsoever, whether for law or fact, which may relate to or arise in the course of the winding up of the LLP, whether such suit of proceedings has been instituted or such claim or question has arisen or arises, or such application is made or has been made, or such scheme is submitted or has been submitted before or during the pendency of winding up petition or after the winding up order is made. These were the jurisdiction of the tribunal. Now, submission of report by the liquidator. The liquidator shall, within period of from the date of winding up order submitted to the tribunal, the following shall be stated in his report. First is the nature and details of the assets of the LLP, the details of the contribution received or outstanding from the partners. Next will be the details of the existing and contingent liabilities, the details of the debt due to the LLP, details of the guarantees, if any, given by the LLP, the details of the subsisting contracts, if any, and any other information as may be deemed necessary shall be mentioned in this report, and the report shall be submitted by the liquidator to the tribunal. Next, which is mentioned under the rules, is the direction of tribunal on report of liquidator. The tribunal shall, on perusal of the report of the liquidator, decides the time for the completion of the winding up process as it deems fit. It shall be based on the liquidator and report of the liquidator, and after hearing the liquidator, order sale of the LLP as a going concern of its assets or pass thereof shall be passed by the tribunal. The tribunal may also appoint for a sale committee comprising of such creditors, partners, and officers or employees of the LLP to assist the liquidator in carrying out the winding up process, and where the tribunal believes that an LLP can be revived or rehabilitative. After looking at the report of the liquidator, if the tribunal feels that an LLP can be revived, it may then direct that an action for revival or rehabilitation may be taken in accordance with the procedures as mentioned in sections of the Act. When a report is received from the liquidator that a fraud has been committed in respect of the LLP, the tribunal shall, without prejudice to the process of winding up, order for investigation, and the provisions for investigation are given under the section 43 of the Act. And on consideration of the report of such investigation, it may pass order and give such directions as the tribunal may deems fit. It may pass such orders. Next is the custody of LLP's properties. Where a winding up order has been given by the liquidator, on the order of the tribunal, forthwith take into his custody or under his control all the property, assets, effects, and actionable claims to which the LLP is or appears to be entitled to, and take such steps and measures to protect, preserve the properties of the LLP. Once the order of the tribunal has been made, the liquidator will take over of all the properties and assets and all the effects and actionable claims of the LLPs, and it will be under his possession. Any of the property, employee, partner, employee, or any other person who is in possession of the property of the LLP shall surrender or transfer the same to the liquidator as of the tribunal may direct. All the property and effects of the LLP shall be deemed to be in the custody of the tribunal from the date of the order for the winding up of the LLP. Moving on to the next is cooperation with the liquidator. The partners, designated partners, officers, and employees, past and present, including the CFO and CEO, that is Chief Executive Officer and Chief Financial Officer of the LLP, they shall discover all the property assets, effects, actionable claims, books of accounts, or other documents and deliver the possession thereof to the liquidator, as the case may be, within 60 days of the relevant date. Relevant date is the date of the winding up order. It shall be the duty of all persons having custody of any property to deliver possessions of the assets to the liquidator. All the partners, designated partners, officers, employees, auditors shall extend full cooperation in the process of liquidation with the liquidator, so that liquidator may discharge his functions and duties properly. The liquidator may hold personal interviews with any such person having custody of property to investigate the LLP's affairs, and it shall be the duty of the person who is getting interviewed to cooperate with the liquidator and be available at the time of interview scheduled for the meeting, and all the information he has shall be shared with the liquidator that he may require and answer all such questions as are to be put before him by the liquidator.
Somebody has put up a question here. What about a property if it is under some litigation? Will liquidator be able to sell that property for settlement or use?
Chetan,
Just
try
to
your
reply,
best.
just to reply that query, if there is a property under the litigation, the liquidator has to do matlab a proper due diligence, maybe to fight that in order to recover that property as per the legal options available. He has to exercise the full legal option to recover that property before distribution.
Just
He
to
cannot.
further add that recently IBBI code is amended for voluntary liquidation, and in voluntary liquidation, it is necessary that they give proper disclosure. So always liquidator has to ask the disclosure if any, specifically if any litigation, that has to be taken, because any litigation pending, no, the dissolution cannot happen. The final closure will not happen. It has to be attended, so that has to be taken care.
Yeah,
It might have taken the years, the
It
common.
might take a years together that the property if it is under litigation.
Yeah, then don't, that's why you have to go to experienced liquidator, and because as I discussed, if, and earlier also I have covered in voluntary liquidation and my webinar in IBC, that the best way of voluntary liquidation is that you can't avoid any litigation by closure. No closure will be allowed with litigation either by you or by creditor. Please note that. You have to attend the liquidation. Without that, it will not happen. That all litigation. That's very clear.
That's why it is preferable in case of any anticipation of litigation that should be closed before starting the liquidation.
Yes. Because you can able to settle and all that, liquidator doesn't have all that.
Yes, yes. You can
flexibility.
write off anything. You can waive off your right, any assets. So then doesn't raise any questions. But if the liquidator has to do these things, they has to follow the complete process.
Rashmika has put up one question. That is only of one of the partner who's willing to forego. I don't know what context this question is there actually.
So she is telling if one of the partner is dead and he wants to go, whether they can go voluntary liquidation under LLP Act, not under IBC. That is the question.
No, for that, if you are foregoing any liability, that will be added into the profit, and the tax is required to be paid on that entire debt as per my limited knowledge of income tax.
Yeah, that is fine. But if that is done then there is no default or anything and no payment, none inability. Whether they can go under LLP Act, voluntary winding up.
They can go under if the company is solvent. Matlab, if the debt is there, so how the company is solvent, how the directors.
See, if the debt is unable to be paid, that means the company is not solvent. One
Yes.
of the condition is if the company is solvent, then and then only you can go for the voluntary winding up.
I
One
think
side you are saying they are unable to pay the debt,
No,
and he
no,
is willing to go.
Mr. Bala, that is
Yeah.
her question, that
Yeah.
there is only one debt which
Yeah.
is due to the partner.
Okay.
The partner is giving, is ready to forgo the same, he is ready to pay tax.
Yeah.
Now whether the LLP can go under LLP Act foreclosure, or it is compelled to go under IBC. That is the question.
For my knowledge, Bala sir can add any. For my limited knowledge, if the company is write off that debt and the balance sheet after that debt is showing the company is solvent, then they can adopt the voluntary liquidation. That is depend on the financials after the foregoing of the tax. They have to prepare the financials. If the financial shows if they are solvent, then only they can go under the LLP. Otherwise, they have to follow the IBC.
Yeah, you are right. Your understanding is correct. Because when the person says that I am foregoing the debt, fine. But after you forgiving the debt, that means what happens in the company books of account, you actually write off the asset, write off the debts. That is number one. And second thing is, even if you say that the other element of taxation, etc., will also come into play. After that, again, you have to assess whether it is the company solvent, the LLP solvent or insolvent. If it is solvent, yes, then the question applies going for the voluntary. Otherwise, it is not. Absolutely, I agree with you, Mr. Chetan, because after doing all the things, the company, if the LLP is solvent, then they can go for voluntary.
Okay, let's, Harshita, please.
Yes, ma'am. Application of assets. Assets of the LLP shall be applied first for the payment of the costs, including expenses, charges, or fees, and remuneration of the liquidator incurred in the winding up of the LLP, and thereafter it is applied for the discharge of its liabilities pari passu in accordance with the provisions of the acts and the rules. So first, the assets will be applied for the paying of the expenses and charges, and including remuneration of the liquidator, and then these assets will be applied for the discharge of other liabilities. And if any surplus is left, it will be divided among the partners as per the LLP agreement. Then the tribunal may also constitute a committee for inspection of the affairs of the LLP, which will assist the liquidator in winding up process. The tribunal has the power to direct the constitution of committee for the inspection of the affairs of the LLP and to assist the liquidator. This committee shall consist of such number of members which will not exceed 12 as the tribunal may order. The committee may consist creditors and partners of the LLP or persons holding general or special powers of attorney from creditors or partners in such proportion as may be agreed on by the meeting of creditors and parties, or in case of difference of opinion it may be decided by the tribunal. So there can be a committee of inspection to assist the liquidator in the winding up process. Next is the submission of periodical reports, etc., to the tribunal. The liquidator shall report quarterly to the tribunal for the progress of winding up. The form prescribed in the rules is form number 13, which will be made before the end of the following quarter. The rule also provides that the tribunal may, on an application by the liquidator, review any order made by it and make such modification as it thinks fit with or without any further directions. So, the liquidator may apply to the tribunal for any modifications in the order if it feels there is a need for the same. There are provisions for assistance to liquidator. The liquidator may, with the sanction of the tribunal, appoint one or more practicing chartered accountants practicing company secretaries, or practicing cost or works accountants or legal practitioners entitled to appear before the tribunal or such other professionals or experts or valuer or agency as he considers necessary to assist him in performance of his duties and functions under the acts or rules. A liquidator may take help of these professionals for carrying out his duties and functions for winding up process. The persons appointed under these specified rules must first declare their conflict of interest, if any. Then there is provision for audit of liquidators' accounts. The liquidator shall maintain proper books of accounts, including the accounts of receipts and payments made by him in the form and manner specified in these rules. The accounts of the liquidators shall be audited in the form and manner which is specified under the rules. The liquidators' accounts are liable to be audited. Then the rules also mention control of central government over official liquidator as liquidator. The central government shall take cognizance of the conduct of official liquidator as liquidator of LLPs which are being wound up by the tribunal. If a liquidator does not faithfully perform his duties and duly observe that all the requirements imposed on him by the Act and rules, or if any complaint is made to the central government by any creditor or partner in this regard, then the central government shall inquire into such matter and take such actions thereon as it may think expedient. The central government then also has the power to direct the local investigation of the books and accounts maintained by the liquidator. The provisions for inspection and investigation of the books of accounts of the liquidator are also provided subject to the approval of the central government. There are certain powers of central government given for inspection and investigation of the workings of the liquidator here. And that's from my side under the winding up of the tribunal. To summarize, after filing of the petition, the tribunal will scrutinize the petition and the hearing for the petition will be conducted. Then the orders from the tribunal will be ordered, and after that meeting of the creditors and partners will be held, and then appointment of liquidator will be done, and after that liquidator will realize all the assets of the LLP for uh, for the claim of the shares and paying out the expenses. And after all the expenses and assets are realized, the order by the tribunal will be passed for its dissolution, which will be reported to the registrar. That's all from my side here.
Chetan, bye.
I think Chetan has
Yeah.
done some practice. Chetan has actually done the winding up under the IBC procedure of the LLB. Maybe we can hear from him.
Yeah.
Mr. Chetan, please.
Just a minute. Chetan, bye.
Dipti, somebody has put up a request to you to conduct the another session for strike off and different companies, etc. and other things.
I told
yeah,
you connect with me otherwise, so I'll connect. There is a confusion or any question, we can take it personally also because same thing. Chetan bhai, just a minute, I think he is attending some. Friends, just hold on. I want him to say a few words at the end, so that's why. Nisha, can you call him? I think some issue is there. Yeah, Chetan bhai.
Yeah.
we were
Sorry,
waiting
sorry.
for you.
Ma'am, there was some technical issue. That's why I connected.
Yeah,
Yes,
yeah,
ma'am.
yeah, I thought so. Yeah, so Chetan bhai, I think a lot of confusion or anything, and so can you just give a brief summary on the this closure of LLP to summarize? Yeah, Chetan bhai,
Just,
over to you.
yeah, just to summarize for a closer winding up, there is a provision under the LLP Act and there is a provision under the IBC Act. For a voluntary liquidation, we have a two option, either for a LLP Act and we can go under the IBC also, under section 59. for a voluntary liquidation with the consent of partners and with the consent of creditor. If there is any creditor, then the consent is also required to be made, either in the case of LLP Act also or in the case of IBC also. The both process are more or less similar under the IBC and under the LLP Act. The procedure at a broader level are same, but the process that we have to follow for we have an option initially to decide whether we want to go under the LLP Act or under the IBC. And in the second scenario, when the company is not able to pay its debt, the entire process is now goes to the IBC only. So if the LLP is not able to pay its debt, so then they cannot go for a winding up under the LLP Act. That is the whole summary. I think if anything specific detail.
Now, also, if you don't mind, can you give a comment? They are asking whether LLP can be strike off as companies. Any comment on your part?
There is a provision, form number 24 is there. We can go for a strike off. We have the condition for strike off of LLP is common as available in the Companies Act also. The process and there is no specific section given under the LLP Act. However, under the rules and the form number 24, they have specified for LLP strike off. But there are conditions if the LLP is eligible to be a strike off. If they are meeting that condition, they can go for a strike off. Otherwise, they have to choose for a winding up.
So the like company strike off, we can do the similar way exactly.
Exactly similar. All process, everything is similar for condition, even for eligibility also. There should be non-operational from the last 2 years. All the compliances up to the operational has to be met. The balance sheet should be nil. All the conditions, we have to make a statement of asset and liabilities just 1 month before when we are filing the petition, after getting the consent affidavit, indemnity, all the procedure that we are following and for the companies, that entire process will be followed for LLP also.
The same way, company voluntary winding up, same way you follow LLP voluntary winding up, you are financially sound, you pass the resolution or take consent of 100% partner. If creditor take their NOC or their consent and go for closure and then dissolution application with NCLT. But if you are financially not sound, then you take under NCLT rule and you file under either financial creditor, operational creditor or LLP itself by partial.
Yes, so just to add, if you are a financially sound, so you have two options. Either you want to go under the LLP Act or you have the option to go under the IBC also.
Right.
Practically, I think if the LLP wants to, my suggestion would be if the LLP wants to wind up either in case of a strike off, if first they have to see whether they are eligible for a strike off, they can go for that is the easiest and simplest way, cost effective, without time consuming. Strike off is the best. If they have a sufficient fund, the LLP is solvent and they are able to pay, so they can adopt section 59 route for a voluntary liquidation, just like a company. The entire process they have to follow. Instead of LLP Act, they can follow the IBC Act for voluntary liquidation also. If in the third scenario, if they are not able to pay the debt, then compulsorily they have to follow the IBC only.
In defunct 1 year or 2 year non-operation? There is a question.
2 year of non-operation.
Now we can take the question and then if whosoever raised the hand, we will allow it.
There is one question is there actually. There is a LLP where total 4 partners, 2 designated partner and 2 normal partner. The 2 designated partner wants to close the LLP as there is no business operations, but the 2 normal partners not responding. Then what are the options available to the 2 designated partner to close the LLP?
I think I'm just reading the question. The two designated partner wants to close the LLP as there is no business option, but the two normal partner not responsible. No, they have to agree with each other. You cannot, with designated partner cannot do alone without the consent of the. Then what are the options available to two designated partner to close the LLP? There is no option. You have to take alignment of all the partners. You have to either change the LLP partnership deed to exclude those two partners who are not responding, or maybe that before anything, the alignment should be there. That is an in-house alignment within the shareholder or within the partner itself.
I think we have covered all the questions. Well, Mr. Bala?
Yeah, questions are not there now. Anybody-
Anyone wants to speak? Anyone wants to raise the hands? We can speak and discuss or argue. Recently, somebody raised the hands. I don't know.
I don't see any hand risen actually so far. There is one hand is risen.
Yeah. Who's there? Miss Divya.
Yes, hello.
Yes,
Yes,
Divya.
Yeah.
Yeah, actually, I'm not sure whether it is related to the current discussion, but it is regarding the conversion of a company into LLP. I had one query and I have been discussing with.
Yeah, sorry, Miss Divya, can you connect separately because that we have already taken in the session.
Divya,
Separate session.
there is a recorded webinar is actually available. Conversion of LLB into company into LLB. That is available on the YouTube. You can actually open and watch. Your queries will be answered actually. We had one complete session on that in the past.
No, actually, I've attended all your sessions and I have attended that session also. But there was one query which in that session also when I asked, it was answered. But I still have a question on that because
Yeah, that
I have been.
put it separately to us, no, not in this.
Okay,
session.
okay, I'll put it separately. Okay, no problem.
Thank you.
Thank you.
Anybody else? Participants, anybody else would like to ask any questions?
Yeah, I think everyone has covered.
I wanted to get some information about the LLB main business activity.
My boss, you have to go to
This also we discussed in the beginning only in the first session.
first session here.
Yeah.
Okay, still people, if you have any question, you can put the mail to us. We will connect to Chetan Bhai and we'll answer, and we'll also answer from our side. Okay, don't hesitate. Further, you can say, and all the participants who are asking the question about earlier session, go to that. If you have additional question, you can write it to us. We'll surely answer it to you. You have all our contact details. Thanks a lot.
Ma'am, just to give one more practical advice for a LLP, because for a companies, for reduction, if there is a surplus of the funds, for a companies you have to go for a reduction of capital. But for LLP, you by amending the partnership agreement, you can reduce the amount of the partner contribution. So maybe by that way, that is very simple. Instead of going to the entire voluntary liquidation process, they can just reduce the partner's capital, and whatever the surplus is there, they can distribute subject to tax liability. Definitely, they can distribute entire funds to the partner, and the small amount can be later on make them eligible for the strike off also. That is in some of the cases that I
Very
have.
good suggestion, participants. This is the advantage of having this kind of experience panelists.
That's matlab for just to avoid any long process for a voluntary, because in any case IBC or LLP Act, that will take around 6 months or maybe higher than that to liquidate, and there is an additional cost.
Yeah, and then Mr. Anil has commented for striking off if the period is not period.
I think under the act that is given for 1 year. Yeah, I agree with Anilji.
I think 1 year I agree. One fiscal year, that is what the act actually says. Actually.
Yeah, earlier we mentioned 2 years, so he has checked and come
Yeah,
back.
it is 1 year.
It is 1 year.
So, Anilji, yeah.
LLB has not done any business from 1/6/22, but sold the remaining stock on January 24. Can we actually file the strike off? Yeah, if you are fulfilling the condition, that is no operations are there, no debts are there, nothing outstanding is there, that 1 year condition is actually fulfilled, you can go for the strike off. Nothing is stopping.
Whatever you are doing for liquidation of the LLP, that will not count under the operation.
Operation means your business operation.
Yes.
What are the main business of the LLP?
Financial year or calendar year?
If you are holding the assets or the remaining stocks just to liquidate the company, that will not count under the operations as per my thing. You are just liquidating the company based on your decision or consent, that will not count.
Then they talk about whether it is the financial year or the calendar year, 1 year.
That is a financial year, I believe. Financial year.
Financial year. We are thinking of forming a LLP with the main purpose of carrying out.
Please, not here. Setting up a LLP separately, not been closing.
Okay. Then that's all. I think we are done with all these things.
Yeah, thank you, Chetan bhai. Thanks a lot for your inputs. Thanks a lot.
Anytime.
Anyone has raised hand? Yes, Miss Divya, again.
Harshita has done a wonderful job in making.
1 minute, Miss
Yeah.
Divya has raised the hand.
Yeah.
Miss Divya?
Divya Mageshwari.
I missed it.
Sorry, I think उस समय वो lower नहीं हुआ होगा. Sorry, ma'am.
Okay. Okay. No problem. No issue.
Okay, Chetan bhai, thanks a lot for your time
No,
and your
my
inputs.
pleasure. My pleasure.
Thanks a lot.
I think Dipti, Harshita has done a very, very wonderful job at putting everything very concise form and explaining the things very nicely. Let us give a big hand to her for putting the things in a capsule form. And definitely from Chetan, we are learning a lot of things, as you rightly put it. Having the experienced people, that actually gives you what's the insight. One point what he has mentioned, when the director, when the partner is having only one loan and no other creditors there, what is to be done? He mentioned very nicely. Strike up is the better method rather than going for the winding up, etc. This is a very, very practical solution. I think we keep adding our value continuously with this seminar. Thanks a lot. I think, Dipti, your last word, we can close down. We can call it a day today.
Yeah, thank you, Harshita, for the presentation.
Thank you, ma'am.
Chetan bhai. Thanks a lot for your time. Thanks, participants. Keep on participating this way. And still, as I mentioned, any query, any arguments, we love that. You correct us. We are aware that every participant is actually participating. Thanks a lot, Anil bhai. You have done a wonderful job. You are participating very actively. You can connect to us. We will still have your all doubts clarified. All the participants, still if your doubts are not clear, you can talk to us, put a mail. Thanks a lot. Thanks everyone. Have a happy weekend. Thank you.
Thank you so much, everyone.
Thanks a lot to everybody. Have a good weekend. We have to meet in the next session next Saturday. Thank you.